I'm going to start the broadcast. So why don't you guys mute?
Okay.
And we're going to go. All right.
The broadcast is now starting. All attendees are in listen-only mode.
All right, welcome everyone. Yeah, it's Clint Coons here with Anderson Business Advisors and Law Group, and I was expecting Dan to make it on the call, but he must have got hung up this afternoon because I haven't been able to reach him yet. So maybe he'll be joining us later. But I want to thank you that took the time this afternoon or this evening, depending on which coast you're on, to join us on this call. You know that this is the second webinar that we're holding. Last week we reached maximum capacity with the number of people that we could have on the one webinar. So Dan asked me to put on another one this week to accommodate those individuals who couldn't make it to last week's because we just couldn't have any more people on the call. So without any other information, some background information. I want you all to know that in the follow-up email that you received from GoToMeeting or GoToWebinar, depending on where it came from, there's a link in there that allows you to download a copy of this presentation. It's in PDF format, so if you haven't done so already, at the end of this presentation, go ahead and click on that link, look for that email, and you can download all my slides. I have some ancillary information that I included in there that I would want you to take a look at, and I'll reference it periodically as I'm going through here. But it just gives you a little more background information on certain topics and other information that we'll be covering. I also have with me three attorneys, Greg Boots out of our Tacoma office, Michael Bowman out of our Las Vegas office, and Rod Butters out of our Las Vegas office. They're here as organizers as well, and they will be fielding questions throughout the presentation. So I've asked them to come on. If you have any questions, go ahead and pose them. Just post it out there, and one of them will answer your questions and reply back to everybody so everybody can see the answer. Because a lot of times people have the same question, and this way it'll all be handled the same, so you won't be asking the same questions necessarily that somebody else did. During this presentation, while you're asking the questions, do keep in mind that I may cover that information, and you might get a response, hey, Clint's going to get to that, just hold off, and if you still don't understand, re-ask the question. So keep that in mind as we go along. I'm going to hit on a lot of information here for the next hour, hour and 20 or so, and then we'll do some questions and answers at the end where I'll just read some of the more important questions, I think, or I'll let actually Greg, Michael, and Rod get on and do some of that as we go through here. So with that, somebody asked me about recordings of this event. Yes, I will be recording this presentation. It'll be available probably in 2 days. Check back on that if you want to view it one more time. But I will be recording it as we go along here. So with that aside, we're going to get started into the presentation. So as you know, many of you are here because you are invested in the dinar, and as am I. If you've been on the first call, or actually my very first call, which was way back in January, when Dan asked me to come on to his conference call one afternoon, he said, hey, Clint, I want you to talk about asset protection. And Dan's a client of mine, and he thought that the information I could share would be valuable to the members. And I'm sure. I said, Dan, that sounds great. I'll be on the call. And then about 5 minutes before the call, Dan told me, he said, hey, this is all about the dinar. Clint, you ever heard about it? Well, at that point in time, it did take me by surprise. I had been told for maybe one or two clients that I have in my database that I talk to on a regular basis, they had mentioned it, but I never really looked into it. So I went on that call and I talked to Dan or talked to the general people on that call about asset protection and taxation in general, and I really didn't get specific on the dinar because I didn't know enough about it. And I understood they told me if people were invested in this currency and waited for it to revalue, and those were all foreign terms to me at that time. And so after that call, I went out and I spent some time researching this particular investment. In fact, I researched it so much and I became so enamored with it that I went out and bought myself my own dinar, made my own investment in the dinar. And I produced what I called my currency report. That's made it around to quite a few individuals. Many of you on this call may have already read that currency report. It's a 7-page report that outlined, some various items that you should consider in dealing with this particular investment. And so from that, we've got a lot of calls from people on how to deal with their investment in the dinar and what they should be doing going forwards, both pre-RV and post-RV. And then talking with Dan and others, I said, Dan, you wanted me to put together a webinar that would address all of these issues, or a lot of the concerns that we get, because we've probably fielded no less than 1,000 calls from individuals on this investment and discuss with them various ways to protect their investment in the dinar and what to do with it going forwards. Some of the things that we're going to be covering tonight, which were right on point, is, I want to teach you a little bit about what to avoid. Because as I started to study up on the dinar, I found out that there's a lot of misinformation out there that needs to be addressed to keep people from hurting themselves with this particular investment. Because too many people get on these conference calls and they promote products. They're not attorneys. They don't understand what they're talking about, and they make people afraid that if they don't take action with a particular strategy, then they're going to suffer untold tax consequences, and the government and everybody else out there is going to come in and take all their investment away from them. And I know some people unfortunately made this mistake and invested in some of these other products, but I do want you to know what the law is and how it's going to relate, even if you've already made that investment. It may not be the information you want to hear. So I'll be covering some things about what to avoid. And then I'm going to right into tax consequences, and we'll talk a little bit about how the dinar is going to be taxed, post-RV, and what you can do to minimize those taxes. That falls right on that. And then we're going to finish it up with how to handle this investment, the things that you need to be aware of when it comes to the RV for the dinar. And so some of the strategies that we've been working with people on now to ensure that everything's set up the right way going into the RV, because it really feels like it's getting closer. I mean, talking to Dan, and he's telling me some things, and it just seems like a lot more information's coming out there. And I know I'm getting excited about it, and I've got instructions if I'm not in the office, who's to handle my investment and where to put it and what to do with it. And so, these as things start moving along quicker and they're going faster, you want to make sure you have all your ducks in a row and you're ready to cash in on this, and it's going to be done the right way from the get-go. Because a lot of times with anything that we do, once the horse has left the barn, there's not much we can do there to bring him back. So we want to make sure that horse stays in the barn, we've got him corralled, and we've minimized our taxes and reduced our overall risk exposure. So that's what I hope to do for you today, and we're just going to get started right into what to avoid. Now, this one is made a lot of play on different calls, different groups out there, message boards. It is what I call the irrevocable trust myth. One of the things that I hear a lot from people when it comes to this particular strategy is that, I'm going to set up an irrevocable trust, Clint, because I do not have to pay tax until the assets are withdrawn. And there's a lot of fancy words for this irrevocable trust: grantor, spendthrift, super, hayseed type trust that's been written according to Scott's on Trust. And one guy told it how it has all these attorneys that currently back it up. And I looked up a few of those attorneys. They've been dead for quite a few years, and that's not encouraging. But the thing about it is that they portray this document as something people should set up to minimize their taxes. And unfortunately, that's not true. The fact of the matter is that if you set up an irrevocable trust that you create for yourself or for somebody else, that is, and you put assets into it, the dinar, and then when it revalues, it's going to be taxed to the trust. And so you're going to pay tax at the trust tax rate. Well, you yourself as an individual, if you had all your dinar, it's all short-term, and you go and cash it in, it's going to be taxed basically at 35%. And you know what? It's going to be taxed at the same rate inside of the trust, 35%. So you may talk to somebody and they say, Clint, hey, it's 35% in the trust, it's 35% in my name, so why is there a problem with using this trust? And I often tell people it's not on the initial revaluation. That's not what I'm concerned about. It's going forward the subsequent years, because in the future years, when you have a trust set up, an irrevocable trust, your top tax bracket is 35%, just like it is at the individual rate. But the difference is the top tax bracket begins at $11,000 in income. Whereas in the individual, it's much higher, upwards of $250,000 before we're going to look at something like that. So with an irrevocable trust, you're automatically being pushed into a higher tax bracket at much lower income that's generated inside of the trust. And so from that standpoint alone, I think people should just avoid this trust because of the negative tax consequences that come along with it. And this myth that, you know, you don't have to pay tax until you pull the assets out of the trust is just patently false. In fact, what they should be saying, and I know they're misstating it because they want to sell these, you pay tax on any money you withdraw out of the trust. That is a true statement. Well, if you pull out $100,000 out of the trust, then it's taxable to you that year. That's $100,000 in the trust income. Well, it's not taxable at the trust rate then, but it's taxable at your rate. So there's kind of a play on words there. They lead people to believe that they're not going to pay any tax on any money they leave inside of the trust, and unfortunately that is just not the case. It will all be taxed. And in fact, this belief that you can avoid taxation with trusts has been going around for years, 20, 30, 40 years. And the IRS is actually focused on it, and it's one of the areas in which they will raise a skeptical eye and take a look at what you're doing. In fact, every time somebody brings this up and they say, Clint, where's your authority for that? Because I'm real high on people giving me authority when they tell me, well, I heard this from, Joe on this conference call who said that the Treasury is going to do X, Y, and Z. I said, show me the Treasury regs. Let's just not take Joe's word for it. And so I would direct you to go to the IRS's website, irs.gov, and when you have some free time, just do a search for irrevocable trusts. And you'll find an area in there where they say that this is a particular concern for them because of fraud and tax avoidance. So it's not just me telling you this, it's also the IRS's view when it comes to this particular investment or tool. Now, something else, you often be told that if you set up an irrevocable trust or these spend-thrift trusts, you'll have asset protection. In fact, what I've been told from many people is they've set up more than one. They've set up 10 trusts, and they put their car in a trust, and they put their house in a trust, and their dinar in a trust, and then they put, their furniture in a trust, and their rings, and maybe even their dog they want to put in a trust. And at the end of the day, they have this impression that they're all protected because there are all these separate trusts set up. Well, the fact is that the trust itself, when you set it up for yourself, it's what's called a self-settled trust. When you set up a trust where you're the grantor, that is a person who established it, you're going to be the trustee, that is the person that controls all the assets, and you're going to be the beneficiary of this trust, the person who gets to benefit from all the assets. I mean, do you want to put your money into a trust and then turn over the control to somebody else and say, hey, manage all my money that I've just earned from the dinar and then distribute it out to me whenever you feel like it? Because I can't tell you when to give me money. It's up to you to control my investments from here on out. Do people want to do that? No, absolutely not. They want to have all that control. Well, if you set up a trust where you want all that control, then you do not have asset protection. And in fact, there's only a handful of limited jurisdictions out there that provide asset protection for irrevocable self-settled trusts. Nevada is one of them, Alaska. I've given you some of that in the presentation, the slide handouts. Those states that offer the asset protection trusts, okay, they will give you those protections of protections from creditors, but you're going to have to give up something, and that is control over your assets. And everybody I talk to, when I tell them, listen, we can set this up for you, but you can no longer control the funds, you actually have to hire a trustee in Nevada or Alaska, wherever you chose to set this trust up. People say, well, I don't want that. I don't want somebody else telling me that I can't have my money. Well, then you cannot have asset protection then if that's what you're seeking with this type of trust. And so I steer people away from it because of the lack of control, essentially putting handcuffs on yourself. And that's not why I've invested. I don't think that's why you've invested, to turn your money over to somebody else in order to gain asset protection, when there's other ways to maintain that same asset protection but also keep the control. So I encourage you that if you've set one of these things up or you're considering setting it up, you reevaluate that position because of the negative tax consequences and the fact that they do not provide any asset protection for you. Now, another strategy I think you should avoid is the one that's made the Dirty Dozen list for probably the last 12 years. That is, the IRS puts forth a list each and every year of the top 12 transactions. They call them the Dirty Dozen, that they are going to scrutinize and that they feel the most tax fraud is taking place within these types of transactions. And the one that's been on there the most and is at the top of their list is offshore strategies. And I've talked to a few people who've told me they're moving their money offshore because it reduces their risk of audit. Well, let me tell you something. Offshore entities do not reduce your risk of audit. In the handouts, you'll see it provided you some ancillary information regarding offshore entities. In fact, they're going to increase your risk of audit because you have to disclose all of your transactions that take place offshore. Each and every year you have to disclose that if you have a corporation that's offshore, if you have a trust that's been set offshore, and there's several ancillary tax forms that go along with this that must be filed. Otherwise, there's severe civil and criminal penalties that go along with it for failing to disclose offshore accounts, offshore assets. And you probably remember last year, UBS Warburg, the IRS was fighting them to get access to their client list because they believed that certain individuals in the United States were not reporting offshore income or hiding income offshore. Well, they got that list. And if you go to the IRS's website and you put in offshore trusts or offshore corporations, you're going to see a list of all the people they prosecuted last year, and many of them went to jail for their particular activities. You know, I'm not trying to convince you that, you know, all offshore is bad. I'm just trying to tell you that there's a lot of areas of offshore that you may not understand, and you're getting into an area that could bring liability to you. And especially with this type of investment and this type of money, that wealth that we're about to come into, and what we want to do with it and the good we can do in the world, I don't think it wants to be out there offshore. So that is something that you need to be aware of. Something here is it reduces income taxes, and that's just patently false. If you have an offshore entity, you set up an offshore corporation, offshore trust, it's not going to reduce your income taxes. If you set up an offshore corporation, you have to pay personal income tax on any money that's generated offshore, even if you don't bring it back into your personal account. You still must pay tax on it. This is one of the biggest falsehoods that's often claimed when it comes to offshore entities, is that it's going to somehow reduce taxes. That is, if your currency revalues and it's in an offshore account, you don't pay U.S. taxes on it. Wrong. If you're an owner in that corporation, you will pay taxes on that money because it'll be included on your 1040. Otherwise, if you don't, you better get used to wearing an orange jumpsuit, because eventually when they do catch you, that's what's going to be your outfit for the next 3 to 6 years. So I would avoid offshore entities for those particular reasons that I've just laid out here. Another strategy that has been bouncing around, in fact, I just talked to somebody today about this particular strategy. And she was told by an individual, again, non-attorney and not even a CPA, that what she should do is create a Nevada C corporation for her investment. And he said that this was the way to provide anonymity and to reduce the taxes after the RV. This comes up a lot. People are told to create C corporations for income tax reduction. Well, if you look in the slides and the handouts in the notes section, you'll find I've given you an example of how it would play out. In fact, with a C corporation, you're not going to reduce your income taxes when the dinar RVs. What you're going to do is definitely increase your overall tax rate. And let me give you an example of how that might work out. Let's assume that I had 3 million dinar and it RVs for $3. Now I have basically $9 million in income inside of my corporation that I'm going to have to pay tax on. And my average marginal bracket in a corporation with that type of income is going to be about 33%. So I'm going to pay 33% income taxes, corporate taxes, on that amount. Now, if I decide to distribute it out to myself as a dividend, I'm going to pay an additional 15% on that. So now I'm paying 48% in overall taxes on the amount of money that I've taken out of my corporation. Heck, if I'd have just kept that in my own name and not even set up the corporation, we'd only be looking at 35%. You just went out and increased your tax bracket by 13% by putting together that Nevada C corporation. It's not going to reduce taxes. It's going to increase your taxes if you have your dinar inside of there. Now, what you should also be aware of is that if you've already set up this entity and you put your dinar into the entity, you want to get that out now before it RVs, because after it RVs, if you pull out an asset that's appreciated, you're going to have to pay tax on it, and the corporation will have to pay tax on it. So they'll treat it as if you just sold it and then distributed it yourself as a dividend, so you get hit with this double tax. So I would avoid C corporations for this type of investment. It doesn't mean that a C corporation may not benefit you in the future. In fact, many of the people that I've talked to, I've explained to them, hey, yeah, putting together a C corporation, that's definitely something we are going to look at post-RV. And this is what a lot of this comes down to when I'm consulting with an individual. I explain to them that we have strategies that are definitely pre-RV, and we have those strategies that are definitely post-RV. And a corporation, in my opinion, falls into a post-RV strategy. It isn't something that we should even consider at this point in time. Another thing is that they provide asset protection. The fact is, you know, with the exception of Nevada, C corporation does not provide asset protection, and that is if I were to sue you, if you were involved in a car accident, let's say, and I got a judgment against you, well, tell you what, that C corporation, those shares in that corporation, they're an asset that I could take from you. So it's not going to provide asset protection. The only state that allows you to have any asset protection with a C corporation is Nevada. It's a new law, so to speak. When we talk about news laws, it's only been around since 2007, 4 years. I haven't seen it tested yet, but they apply charging orders to Nevada corporations. And it remains to be seen how an out-of-state court might interpret that, because it's the only state that provides this. So I'm not even that comfortable saying that a Nevada corporation will protect you, because it has yet to be tested by the court system. So those are two main falsehoods that I often hear when it comes to setting up entities for, or three entities I often hear that are promoted by individuals that people should set up for this investment. I just want to caution you that, seek a second opinion on this, and then ask me, if you're talking to somebody about this right now, start asking them some of these questions and see what their responses are. But often I tell people, ask a person if they're an attorney, ask them if they're a CPA, because they have a license to protect, so they have no incentive to give you any information that may lead you astray, because at the end of the day, it's the professional that will be, or will have the most risk of loss, because they could lose their license. So they're going to be very cautious. When I would say, overly cautious, but they're going to keep you on the straight and narrow. So you got to be careful there. So let's get past that. Good. We're done. Now we're going to talk about tax consequences of the RV. And I can tell you this is something that I receive at least 3 or 4 emails a day from individuals just discussing international taxation, asking me questions on Canadian taxation, U.S. taxation with the dinar. What's going to happen? How much should I be setting aside? Well, you might be amazed to find out some of the facts here when it comes to taxes with respects to the RV. So the income tax rate, here's what you can plan on. If you've held your investment, okay, for less than a year, it'll be ordinary income tax. That is, you're going to be taxed at 35% on that investment. And so what you should do after an RVs is just plan on taking 35% of whatever you've generated and putting that aside for taxes when they have to be paid. And I'll discuss that in here in just a second. Now, if you've held it for more than a year, then I would claim that it's long-term capital gains. And if it's long-term capital gains, then it's going to be taxed at a lower tax rate of 15% for you. So you figure then if it's long-term capital gains, you want to put that 15% of that money aside to cover your taxes at the end of the year. Now, some people often ask me, well, Clint, how do I prove that I bought it over a year ago? Well, typically when you acquire it, you have a record from the person who sold it to you stating how many dinar you acquired and on what date. There's your proof right there. Make sure you keep that. You would have records of the certified check that you sent or cashier's check, however you paid for it. There's another record right there. So you want to make sure you maintain those records, because that is what would save you in the event of an audit if they challenge you. And believe me, one of the things that the IRS is going to do, from my standpoint, is if they audit people, which it stands to reason that you will be audited, or not everybody, but good people will get audited on this because of the amount of income they're going to generate. Their position is that everything is short-term. I heard somebody last week tell me their position is everything's long-term on this investment. No, why would they ever do that? That produces the least amount of tax revenue. They're going to take the position that it's all short-term, and you have to prove to them that it's actually long-term, and that's why documents, records are so important. And for people that I've been working with, when we set up the LLCs, we're ledgering the interest over. That's something that I'm asking them, when did you acquire it? So we're making sure that we have a record now that we're putting in business records to further bolster the argument that this is a long-term investment. It's been held for more than 1 year. And so documentation is important, making sure that when you set up an LLC that it's set up the proper way. I talk to a lot of people who've set up limited liability companies, and I start, asking them, well, are your dinars ledgered into the LLC? And they ask me, what do you mean by that? And I said, well, how do you know your LLC owns the dinar? I don't know. They just set up an LLC for me. They didn't ask that question. That's really important. You want to make sure that those types of things are getting answered, and the I's are dotted and the T's are crossed. Something about taxes, too. Here's what I plan to do. After this thing goes, and the dust is settled, a month out, I'm going to submit for a private letter ruling. I'm going to take one of my clients, I'm going to use them as the guinea pig, so to speak, and we're going to submit for a private letter ruling just to get an idea of what the IRS thinks about this. And we're going to put in there the private letter only, ask them, if you've held it for more than 1 year, how should it be taxed? And if it's less than 1 year, how do they plan to tax it, and how much should be held for federal income tax purposes? And that's just going to really answer the question. We'll be done with it at that point in time. But the thing is that, should you be concerned for the RV date? No. Don't worry about it. You have time to pay your taxes. It's just something you need to keep in the back of the mind and know that these issues are out there. All right, when are your taxes due? Well, that's a simple one. Taxes are due on April 15th of the following year in which this RV occurs. Okay, when the RV happens, you don't have to pay taxes immediately on that funds. Federal income tax requires that you pay taxes the following year on this money, because if it's a short windfall, a new windfall, you're not going to be taxed on it immediately. So what you can do in that situation is you can plan on paying tax when you file your tax return, so you're going to have plenty of time to do that. All right, gift taxes. That's another issue that we're facing when it comes to the RV. What you need to know about the gift taxes is that $5 million lifetime exemption. This expires in 2013. That's how much you can give away tax-free, but then you're going to burn up everything else for the rest of your life, and then when you go forward, you're going to have a lot of money that you won't be able to pass on free of estate taxes in the future. This is something that is a mistake that most people are missing. They're missing the ability to move money now and not even affect their lifetime credit. Their lifetime credit is actually going to go down to $1 million in 2014, so depending on when you start this gifting, we're going to have some issues. So I tell people over and over again, from a gift tax standpoint, you need to start moving your dinar to your loved ones that you plan to give it to today. Get it out of your name, because it's not worth anything from, when I say not worth anything, relative to what it's going to be worth. And so it's time to move it now. Make the gift now so it's not included for gift tax purposes or included in part of your estate for estate tax purposes at a later date. This is really important here because those rates are typically 55%. Right now they're low at 35%. In 2013, you're going to be paying at 55% of your money that you're going to pass on to your kids is going to disappear. So I would make sure that gift is made now rather than later. So what can we do then to reduce our taxes? Well, I can tell you this, that tax reduction, there's only one strategy that I know of that I've come up with that will allow people to reduce their income taxes, and that is the Charitable Remainder Trust. Now, this is something that I got hit with right away after I went on this call with Dan back in January. People were clamoring, well, I want to reduce income taxes after the RV. I need to go out there. I need to set something up. Okay, you can do that, but you have to understand how it's done, because a lot of people have misconceptions about this charitable trust. They don't understand what comes along with it from a restriction standpoint. Now, see, it will minimize taxes on revaluation. And what I mean by that is, if this Charitable Remainder Trust is a charity of sort, and that is when you set it up, you intend to give away whatever remains in that trust, that is at least 10% of your assets, to a charity when you die. So you set up a Charitable Remainder Trust and you put your dinar into it before it RVs, or I mean right after it RVs, and then as the person who controls the trust, because you're going to be the trustee, so you're the grantor, you're the trustee, and then you're what we call the lifetime beneficiary. The ultimate beneficiary is going to be a charity, and I'll show you that in here in just a minute. So you're the trustee. That is the person who controls the dinar that's inside of there at that point in time. You will exchange the dinar, and the money will roll into the trust. That is, on reevaluation, the funds will be converted to U.S. dollars, and they'll roll into the trust. Ordinarily, if you have that in your own name, that's a taxable event. But inside of this trust, it's non-taxable, because the ultimate beneficiary is going to be a charity at the end of the trust term. So the government affords you this tax-deferred nature. Not only is it tax-deferred when you exchange it, but all future growth is going to be tax-deferred. The only time income taxes will be paid is when you pull the money out. So when you set up a Charitable Remainder Trust, you can avoid paying taxes on the RV on those funds that you place into the CRT. Now, sounds great, and I have a lot of people ask me about this. They say, Clint, they call me up and they go, I need to set up a Charitable Remainder Trust so I can reduce my taxes, and I want to get it set up yesterday. And they're shocked to hear this. I tell them, no, I'm not going to do it for you. You don't need it set up yesterday. You need it set up tomorrow. And that tomorrow is after the currency RVs. That's when we'll be looking at setting up this charitable remainder trust, not beforehand. I mean, there are some people possibly that it would make sense, but they're going to have a lot of dinar, because what you don't understand with the charitable remainder trust, and many people don't understand this, is that it doesn't make sense in a lot of situations with people I've dealt with, because they just don't have enough, in my opinion, to make this work. And here's why. When you set up a charitable remainder trust and you put your dinar into that trust and it revalues, and you now have, say, let's assume $2 million inside of there, yeah, there's $2 million you can turn around and invest with. But it's not $2 million you can reach in and grab out gobs of money and say, you know what, my aunt's really sick. She needs $500,000 for medical treatment. I'm going to go to my CRT and pull $500,000 out, and I'm going to give it to my aunt. You can't do that. That's a prohibitive transaction, and you can get in some serious trouble if you use a CRT in that manner. I mean, I know from firsthand experience. I was involved in a situation where I was called to testify in the use of CRTs in a federal tax trial where an individual was prosecuted for misusing a CRT in this manner. Basically, this individual, the defendant, used it as his personal checkbook. He did not abide by the restrictions that were set up inside of the CRT. And what I mean by that is that the government will give you this great tax benefit, but it comes with a set of handcuffs. And if you don't like the way those handcuffs feel and you operate outside the handcuffs, well, then you're going to figure out what a set of bars feels like for 6 years when they put you in jail for not abiding by the rules. And that's what happened to this individual, because he could not abide by the restrictions, and that is, you're entitled to an income stream from the CRT based upon a number that we crunch when we set it up, and that is based upon your life, I mean how old you are, so your life expectancy at the rate right now to get into what it means to you, but I can just tell you this. Let's say you're about 58 years old. We set up a CRT, and we can obtain for you a 10% annual payout. If you have $2 million inside of that trust, you receive $200,000. Next year, if there's $1.8 million inside of the trust, you get $180,000. See how the numbers work? You only get 10% of whatever's inside of there. You can't take out any more than that once the CRT is set up. So for a lot of people that I've discussed this with, you know, they have a couple $1 million in dinar, $2-3 million in dinar, and they think they need a CRT. And I say, wait. I don't know if you really want a CRT. If you have $3 million in dinar and the RV comes out at $2, that's $6 million. How much of that do you really want to tie up in this type of manner where you cannot access it? What happens if it comes out at $1? Now you're looking at $3 million. See where I'm going here? This is why we wait on this particular entity, because the RV rate is so crucial to deciding or determining whether or not this is going to work for you. Because the last thing I want to do is see somebody in a situation where they put all this wealth inside of their CRT and then they just can't live the lifestyle and do the things from a charitable standpoint that so many people have told me that they want to be doing after this RVs. And that's a big misconception right there when I talk about a charitable standpoint. You know, you're not going to be gifting from the CRT to charities. None of that takes place until after you pass away. Only thing that happens with that CRT while you're alive is it pays income to you. So it's a great trust to set up for income tax deferral purposes, but typically I think you need to look at this if you have more than 3 million dinar and you're over 50 years of age. If you're under 50, I can set one up for you, but the trust will only run for 20 years. It will not run for your lifetime, and you'll receive a 5% payout over 20 years. So you won't be getting as much money as you may possibly think you're going to be receiving. So that's something you need to be aware of with the CRT. It's a great tool, but it may not fit into your situation depending on where you're at. So let me just show you a little diagram I put together, some people and some dinar in here. So we got a husband and wife, and they decide that the CRT is going to work for them. So they create the CRT, and then now at that point in time, after the CRT is created, the dinar will then be exchanged for dollars. The husband and wife are listed as the trustees here, and they're the beneficiaries. So they're going to receive a payout out of this trust on an annual basis, and the income inside of it is going to grow tax-deferred, or what we call tax-free growth. So the money continues to grow inside of the CRT. You can manage it. You can invest in the stock market. You can invest in real estate. You can grow your funds. You invest in gold if you want to. And then you're going to, as I stated earlier, you're going to pull some income out of this trust based upon a percentage that we tell you that that you can pull out, and that number comes from the government. And so that income is going to go out to you on an annual basis. And then when you and your wife, or just you, when you pass away, then that trust has to pay out to a charity. So it's going to disappear. Now, the charity that you pay out to can be what we call a family foundation. So we can actually convert this trust into a family foundation for you. For those of you that this makes sense, might work for you in your strategy, we can put together a family foundation that your children can run. I probably have, I don't know, 100 clients that are in this situation right now, that they have a family foundation that was created for them by their parents that a lot of money was placed into, and they run that foundation now, and they draw a salary off of that foundation, so they're doing all right from that. So it keeps the wealth in the family. They're giving away 5% of the assets on an annual basis like they're supposed to, because that's, I get a lot of questions on that. How much do I have to give away if I set up a foundation? You only have to give away 5% of the assets on an annual basis. So you can keep the rest in there, keep them growing, keep them working, so you have more money to dispense to various charitable organizations in the future. But the Charter Manor Trust is a tool that can be used to reduce your taxes, but you need to understand it, and it has to be right for your situation. And so I just want to caution you, it's something we can set up, but I think it needs to be put it into that post-RV strategy. I've told a lot of people, once the RV comes about, cash in whatever you want, but that which you think you want to hold off to defer taxes on, set it aside. Give me a call. We'll set this thing up and get it running for you. And then we can do the exchange through the CRT and minimize some taxes on that. So that's a strategy that will work. It just depends on your situation. Now, some pre-RV items that I want to cover. Now, these pre-RV items I think are extremely important. This is what I get the bulk of my calls on, and the bulk of my discussion is based upon this, not on the post-RV strategies. Because I tell people, as I stated earlier, I've been hitting that post-RV, we don't know where your money's going to go. I was talking to somebody today about post-RV strategies. This person had some entities, and they said they want to do this, they want to do that, and they want to do this. I said, why don't you give the money to the person today, or the dinar to them? Well, I don't know what the RV rate's going to be, so I mean, I want to give them all that. Well, there we go. So that's something that's going to happen after the fact that we can't plan for now, because there's different variables that are going to influence what we're going to do after the currency RVs. And so when I move strategies into the post-RV column, what I tell people is that it's not that we're dismissing these strategies out of hand. What I'm telling you is that let's wait. Let's focus on strategies that benefit us pre-RV and post-RV. And then once we have exchanged our funds and the dust settles, you've gone out to San Francisco, and you really sit back and take a deep breath, then we will look at what we can do going forwards. Because you may change your mind about what you want to do with your money. Maybe some of you are interested in real estate right now, but after the RV, you don't want to do it. You want to do something else. So let's just not run out there and set up strategies or entities for things, or even discuss them really at this point in time. What we need to focus on are those tools that provide benefit for you today, and those strategies that won't work for you. And that's why I wanted to put this webinar on, and Dan really was excited about getting me on this call and putting this thing together, because he gets hit with these questions all the time. He said, Clint, we really need to get the information out to people now so they aren't making mistakes, because as this thing gets closer and you start to feel the excitement in it, people start rushing into things. So pre-RV items that we need to consider: gifting, asset protection, privacy, and estate planning. Now, gifting. This is something that I've been talking to people about from day one. How do we gift away the dinar to those individuals that we want to have it? Well, you have to understand what the elements to a completed gift require. Number one, intent. That is, I intend to gift it to you. I talked to somebody yesterday, I believe it was, and she told me that she bought some dinar for her children. Okay, great. You bought it for your children. I said, have you told them yet? No, I haven't told them. Well, have you given it to them yet? Well, of course I haven't given it to them yet, Clint, because I haven't told them yet. Well, then you have not satisfied the two other requirements for a valid gift, and that is delivery and acceptance. That is, in order to make a gift of something to someone, you have to have the intent, and that's really easy to prove. You could say, hey, I bought this, to give to them. But, how is somebody going to say you didn't? But then you actually have to show that you gave it to them and that they accepted the gift. Without those two other elements satisfied, you have not made a completed gift of this investment pre-RV. And if you give it to them after it RVs, then you've just now made them a gift of a lot of money, which would possibly be subject to gift tax. And so you have to be careful about how you go about gifting your currency to somebody else. I mean, a lot of people will do this. They say, Clint, I put together a letter, and it says, I intend to gift my dinar to my son, you know, and I sign this letter. And again, I ask him, did you give him the dinar? No, didn't give it to him. Well, again, unless you give him the dinar, and people say, well, I don't want to give it to him because he may blow it. He may sell it. He may lose it. Well, then if that's a problem, we need to look at alternative strategies in order to make him a gift of this dinar rather than making it just an outright gift of the currency, because obviously that's not working for you. So we look at other ways to make a completed gift. Now, if you, as I stated, if you want to give it to him outright, well, you can do that. That's a completed gift. You could set up an irrevocable trust. Now, you're probably going, these darn attorneys, they talk out of both sides of their mouth. Clint just said you shouldn't do an irrevocable trust. Well, again, so what did I say and what was heard? Okay, I said that an irrevocable trust that you set up for yourself is not going to work. But you could set up an irrevocable trust for a child and then give them the interest in the trust. They would be the beneficiary. You'd be the grantor. You'd be the trustee. And I know several people who have done this. They've hired somebody to create an irrevocable trust for them, or they bought this irrevocable trust and they set it up. They put dinar in it and they listed their kids as the beneficiary. And they said, see, Clint, my kids now have beneficial interest in a trust, and each of them have their own trust, and I control it all, and I just gave each of them 500,000 dinar. I'm done. I've satisfied all of the elements of a gift. Well, no, you haven't. Now, see, here's the thing where it comes to getting good legal advice rather than buying a form document that you're not sure how to operate or how to set up. Just like everything else, the three elements, intent, delivery, and acceptance. You set up a trust. You put the currency into the trust. If you do not tell the children that you put the trust together and that they have the right to pull the assets out, this is what we typically refer to as a crummy letter. And it's not because it's a poorly drafted letter. What you would do is you would send your kids a letter stating as follows, son, I have gifted to this trust of which you are the beneficiary the following amount of dinar currency. You have 30 days to ask the trustee to remove those funds. If you tell me you want those funds, I will distribute that currency to you. If you do not ask for me to distribute it to you, then I will hold that money in trust and continue to invest it for you. Absent having that letter, you've not made it a completed gift, because you have to give them the ability to pull that money out to make it a completed gift. And this goes back to a court case, Commissioner v. Crummy. This is an individual who did this. It wasn't with the dinar, of course, because this happened back in 1970-some. He actually put some money a bunch of money into a trust for his kids, and he sent them out these letters saying, hey, I put $1 million in. If you call me up and ask me within 30 days to get it, I'll distribute it to you. Now, he probably told the kids at the same time, listen, you ask me for that money today, you'll never get another nickel from me, so you just best ignore that letter or tell me you don't want it. So he did this, and then when he died, there were several $1 million held in all these trusts for his children, and the IRS looked at it and they said, hey, that should be included in his estate for federal estate tax purposes because Mr. Crummy still owned those assets because he was controlling them for his kids. The courts took a look at it and they said, wait a minute here. He told the kids that they could pull the money out. Since he told the kids they could withdraw the money, and the fact that they chose not to has no bearing on whether or not it's a completed gift. The fact that he gave them the right to pull it out gave them sufficient control over those funds to make it a completed gift for gift tax purposes. Therefore, it was their money, not Crummy's. And hence the term crummy letter was coined from that case. And so any attorney who creates an irrevocable life insurance trust or a gifting trust will always put together a crummy letter for each beneficiary to ensure that it satisfies this test to make it a completed gift. So that's crucial. I've seen several trusts created, and that information has never been provided to a beneficiary. If you're in that situation right now, I suggest that you give your children something similar and then get them to either sign off on it and say they don't want it, or just show that you've sent it to them and then they chose to ignore it. Now, if they're minor children, you're going to have to do a little more. You have to give it to the guardian. It gets a little more complicated in order to make that gift. Now, another way to gift an interest in your investment, rather than give it outright or use a trust, is to use my favorite, which is the limited liability company. I mean, I set up several of these for people. What we do is we put the money into the LLC, the dinar into the LLC, and then we turn around after we've got it all set up and we've got our bank account there. We then turn around and we gift to our children a portion of the LLC. We say, here you go. You're now a member with mom and dad. You're great. You own 10% of this limited liability company. Maybe you have two little miracles that you brought in, and so they own 20% cumulatively, and you own 80%. And they're smiling from ear to ear because you just explained to them the benefits, what's going to happen in the future, and how their life is going to change forever. But what they don't realize is that you're in control, and we're going to discuss that when we get into the LLC here. So you can make a gift that way by utilizing the limited liability company, making them a member with you. Now you've satisfied the requirement to complete a gift because they're now on the membership rolls. So, outright gift to the dinar, recipient has to have full control. Recipient must be responsible for exchange. So if you go this route and you gift them the money outright, make sure that you give them the ability to exchange it. That is, I've told people before, if they're not going to utilize the tool that I just discussed, then they want to give it to them, because I know a lot of people, they were giving to people who are mature, 40, 50, 60 years old, parents. Just send them the dinar. Send it in an envelope, and they'll have it at that point in time. And also send an email saying, hey, I'm sending you this currency. Please send me an email back when you receive it, just so I know that you got it. Now, there's your audit trail right there. If somebody ever challenged you on whether or not you gifted them any dinar, well, you got this email string. I mean, the electronic age is great for that. It leaves imprints everywhere. Now we know, hey, you intended to gift it on April 1st of 2011, and they sent you back a confirming email on April 5th. They have the currency. And, of course, they exchange it. You don't exchange it for them. They got to go and exchange it. And then, of course, they'll receive the money after the exchange. So we talked about the trust. You control the trustee. You got to have that crummy letter. One thing that I didn't cover is the trust must file an annual tax return. That's really important if you go this route. You got to have an annual tax return filed with the trust. And that's one of the reasons, you may not want to set one up, because you're going to be pushed into those higher tax brackets when you have the trust. And of course, you should only have one beneficiary per the trust. And of course, make sure you get a bank account set up. I mean, the mere fact that you create the trust and you say that it holds this dinar, you put it on a Schedule A, it's best that you have a bank account ready to go, so when the exchange occurs, you can roll those funds directly into the trust account. You're not scrambling at that point in time trying to figure out how to get that account opened. Okay, let's talk about the darling here, LLC. Why do I like this entity? Well, if anybody of you on this call has talked to me about it, you've probably heard me discuss it in detail, why I think you should set it up. I mean, my investment is held by my limited liability company. I think Dan, he's done the same thing. We put the investment into an entity that is going to hide it from prying eyes. I mean, let's face it, I don't want to have an additional 25 relatives after the RV. I don't want to find out that I have 100 more friends than I knew I had before the RV, because of the fact that now I have this money and people start showing up. I mean, we know how it goes. If they think you have money and they're looking for money because things aren't working out for them in life, they may come knocking on your door. I don't mind being charitable and helping people along, but I want to do it on my own terms. And privacy, for me, is extremely important. I don't want people to know what I have. I mean, you don't want to be seen around town after the RV as this guy right here, because everybody's going to come knocking on your door. What you should be focused on is after the RV, you should look like this guy. Okay, that's important. Think about it from an asset protection standpoint. Okay, not only to keep these relatives, these are so-called relatives away that may come looking for you, but how about just creditors in general? People who think they can make a buck off you, that are looking for a way to sue you. You've heard people stop and short, and get in front of your car and slam on the brakes, and you rear-end them. You rent out, you buy some property, you rent it out, they know you have money, they may claim that there's mold in the property, and so they're going to come after you and shake you down in a environmental lawsuit. I mean, there's just so many different things that can come up in your life when you have money that never affected you before because you were not worth suing. now you're definitely an attractive target. So you don't want to be known as that target around town. You want to keep your affairs private. And what an LLC will definitely do for you is keep your affairs private by keeping that money out of your personal name. You'll have it in a limited liability company in a different name. If you set it up in Nevada, it's in a different state. So it doesn't run through your personal account. It's in this Nevada account that you control. And when you need money, you just dribble it into your personal account as you want to spend the money, rather than they're showing up one day, $5 million, $10 million in your personal account, and your local banker there, the teller, she looks at that account one day when you go in to make a deposit or make a withdrawal, and she just look at you and say, wow, where did that come from? What did you do? Did you sell a business? Now, you walk out and she's looking over her shoulder saying, hey, friend, did you know that Joe here, look at his account statement. Have you seen that many zeros before? That's not how we want to be known around town or amongst our friends. So I can tell you what, I haven't told a lot of people about this. My personal friends and family, I don't share this type of information. When this happens, that money is going to be there. I'm not going to, go out and all of a sudden buy huge houses and cars. I know some people told me they want to do that. That's great and all, but I just, going to continue on living the way I do and do some charitable things that I've always wanted to do that this is going to allow me to at this point in time. Well, I also can do some things for myself. Charity does start at home, don't get me wrong, but the thing is that people aren't going to necessarily know that you've gone from this amount to this amount of money because there's no way to really track it when it's held in an account that's not in your name, it's in a company name that you control. So that's really important. Number two, control over the dinar both pre-RV and post-RV. This entity, the LLC, the reason I tell people they should be setting it up is that it gives you control today, gives you asset protection now, and then so after that RVs, you also in control of it when you exchange the funds into it. I mean, you don't have to rush in and exchange it all at one point in time. You can exchange a portion of it, let it roll into your RV. Dan and I were talking about this a couple weeks ago on a call. He's telling me he's going to, hold on to it and maybe just do a little bit and then, look for it over time and exchange, chunks here and there. Well, all of that as he's exchanging it will roll into his LLC that holds this investment. The LLC will hold the funds that have yet to be exchanged, so that'll be fine. And so it's going to give him control. So he'll be the one as the manager of his LLC deciding when the money gets exchanged, when it's going to be distributed, to whom it's going to be distributed. If you brought children in, as I've already alluded to, and they're members in your LLC, great. They now have come into a sizable, $1.5 million worth of currency, but they can't spend it. I mean, you'll be able to make sure that they're not going to lead a destructive lifestyle. If tragedy does strike, they're involved, say a divorce occurs, they're not going to get the money. The ex-spouse can't come and take those funds from them because you'll be the one always in control of those distributions, and they can't force you to do anything with the distributions. And so from that standpoint, the control, I think, is extremely important. And many times people don't understand the actual benefit of control. Everybody gets focused on ownership, but if you control it, that's better than ownership. I'd rather control it and not own anything because I can direct the money wherever I want. So that's an important aspect. And, the main benefit that's also going to come from setting up this entity, the chief benefit why a lot of people elected to set up an LLC with us is to protect the investment from their personal liabilities and to those to whom they have gifted their interest. So that if something were to happen, the way the LLC works is that if you have money inside of a limited liability company in this asset, that if you set the LLC up in the appropriate state, and one of the things that we look at here is lower taxes and privacy. All these are provided through state law, and that's why when we come down about talking about where you want to set it up for asset protection purposes or lower tax purposes. I'll give you an example there. Kind of going to go off topic here, but it needs to be addressed. People that are living in California, they might think that they can settle the LLC up there in Texas, and it's going to be fine. Well, it won't, because you're going to pay a higher tax bracket in those states because the LLCs in Texas or in California have a franchise tax, gross receipts tax that kicks in after a certain amount, and you don't want to be paying an additional $5, $10, $15, $50, $100,000 in just tax because the form of entity you chose to hold that investment requires you pay additional tax on that income. So that's why we look to states like Nevada or Wyoming or some other ones to set this up. And so that's really important. Another factor that goes into this as well is is, business purpose requirements. Here's a great one that I've talked to people about before, where their attorney will tell them, oh, well, you can just set it up here. Our state laws are just as strong as Nevada from a protection standpoint. Well, I'll grant you that. Maybe they are, but when it comes to piercing a limited liability company, what we call reverse veil piercing, Nevada is one of the best states to fight that argument off. Because if somebody's coming after you and they really want your money, they're going to throw everything they can at the judge in order to find a way to break it. Well, Nevada does not have a business requirement. And think about it here. Well, you've got cash. You have it set inside of an LLC. Not a lot of business going on there as long as it's holding on to cash. So if somebody comes after you, they'll say, hey, you set up this LLC. Where's its business purpose? You don't have one. It just holds cash. Therefore, we can pierce it because an LLC, let's say it's filed in California, let's say it's filed in Arizona or New York, New Jersey, it's got to have some business going on inside of it. It just can't hold investments and do nothing with it. So that is an argument to break the LLC and destroy your entire asset protection plan. That's not going to happen in Nevada because Nevada says, hey, do what you want. Business is what you make of it. We do not impose upon you an actual business requirement. And that's why when I talk about top jurisdictions, I put the Nevada right up there at the top of this mountain. Now, one of the best features of setting your assets up in Nevada is anonymity. And when you set it up there, we create an LLC for you. You're not going to be listed on that LLC. We use a nominee attorney that stands between you and the rest of the world. When I create a Nevada LLC, my client's information is not disclosed. The only people that know that my client has a Nevada LLC set up is myself, my client, and whoever they want to share the information with. And typically that's going to be their bank. That's it. Nobody else. Because Nevada is one of those few jurisdictions that permits somebody to create this form of entity where we use this nominee individual, and we use an attorney, a partner, and this law firm has served, he's on about 17,000 different entities that are filed in Nevada. He's listed there as a nominee, and behind each one of those entities are my entities and all of my clients. So they provide this protection so nobody knows that you have this company or the money. So that's big. There's no tax in Nevada as well. The entities are not taxed. So your LLC, you don't have to worry about the issues we have in Texas and California and a bunch of other states that your LLC will be subject to any franchise tax or income tax because Nevada does not impose that on their limited liability companies. But first and foremost, one of the reasons why you're going to choose a jurisdiction like that, and this is, people have a lot of questions. They say, Clint, what do you mean by asset protection? How does it protect me? So if somebody sues the LLC, the assets are protected. Well, nobody's going to sue your LLC because your LLC isn't doing anything. That's why we're going to Nevada, because we're setting up LLCs. They're just holding cash. That's the best part about it. The LLC does really nothing but protect my cash. Who does something? I do something, you do something, your wife, your kids. They're the ones that are involved that create liabilities for us, and that's where the lawsuit's going to come from. So how do we protect our investments from our personal liabilities, the things that we cannot predict in life? Well, that's what the LLC will do for you, because if somebody were to sue you and they were successful in that lawsuit and they get a judgment against you, what can they get? Well, the only thing they can get is a charging order against your LLC. And what does that mean? Well, it means this. Your LLC stays intact. You still have all your money. You still control all your money. They don't become a partner with you. They can't force you to give them money. They can't force you to sell your interest. They can't force you to liquidate the interest. All they do is they sit down there and they wait for you to take out distributions, which you'll never do, because why would you take out a distribution if it's going to have to go to your creditor? So they just sit down there waiting for an occurrence that will never take place, because you will never do this. You will keep that money for yourself, and if you need to take money out, you'll borrow it out, you'll pay it out to yourself as a management fee. You're not going to pay it to a creditor that's got this ridiculous judgment against you because they found a jury pool that their claim to fame is watching Jerry Springer all day long, and they saw this as another opportunity to show up on a quasi-game show when they went and they sat on that jury pool. That's not something you're going to have to worry about because your funds are going to be protected. But here's something else. Here's the stinger in this limited liability company that people do not realize. If they want to go down, they want to go after you. And that's this provision right here, that if they come after you under, I would just tell them under Rev Rule 77-137, they're going to have to pay your tax liability. Now, what I mean by your tax liability overall, no, but any income you generate inside of that LLC that they wanted to slap a charging order on in Nevada, which they're right there, they'd have to go to Nevada to do this. You would tell them that they're going to be responsible for your income taxes on anything that you're making off that. Just think if somebody sued you right after it RV'd and you exchanged all those funds and you had $9 million and taxable income and you drop that bill on them, you could imagine that they're going to be looking at their attorney right now and thinking, I got somebody to sue, and it's no longer Clint, it's going to be my attorney for putting me in this unfortunate situation. Now, why does it work this way? Well, this is something that comes up a lot. Again, I've been talking to people, and they talk about their LLC that they've set up. They went to Zoom, to create their LLC, or they went to some other individual that was selling some forms, and they set this company up and think, I have these protections. You really don't unless your operating agreement provides these types of protections. And what's really important to know is that your operating agreement specifies how the control works, when you have to distribute money, how you're protected from creditors. I'm giving you an example of some of the language in our operating agreements, that similar language that we like to use. This is just paraphrasing some stuff. But if you read this, it says that, if somebody gets a charging order against you, they shall report incomes, gains, and losses, deductions, and credits with respect to such membership interest. It says, hey, if you want to put this charge order on my interest, you're responsible for my taxes, partner. And this is what's really a benefit of having this type of entity set up, is it's a deterrent. I mean, you talk about deterrents. I think back about cats. When I was a kid, I wanted to have a cat. And my dad brought home this mouser because we lived on a small farm, and he was going to put it in the barn to kill some of the barn mice. Well, I'd always wanted to have a cat, so I brought it in the house right away, and it never actually made it out to the barn like it was supposed to. And it was semi-feral, and the thing would scratch and would jump up on counters, and so my dad would whack that cat and knock it off. And he did this enough times, finally that cat quit jumping up. Now, why is that? Well, a lot of people will tell me when I ask them this question, well, the cat learned that you jump on a counter, it gets hit, and it doesn't like to be hit. No, typically it could have been that, or it could have been that its equilibrium was messed up. I don't know, but cat learn. Now, what does that have to do with asset protection? Well, people look at that and they say, that's cruel. Why would you do that to a cat? And I've been over to people's houses before, and they sprinkle powder. Literally, I went to somebody's house one time, and there was powder on their couch and powder on the table. I said, is this dust? Immediately, that was going through my mind, and I asked him. He said, no, this is for our cat. Our cat comes along, and he smells this stuff, and it must smell like dog to the cat. They don't jump. And I sit down, a big old dust cloud goes flying up, and heck, it worked on me. I didn't want to sit on any of their furniture either, so it keeps people away. So you have this cat be gone, and so you see that by sprinkling this stuff over their furniture, it made the cat stay away. Well, what I want to do is sprinkle these protections over your investment, and we will make attorneys stay away, and we call this attorney be gone, because they're going to come along. If they smell this literally, they're not going to want to pursue you. And that's why it's so important when it comes to asset protection. You put together strategies that prevent lawsuits rather than encourage them. When you own assets in your own name, you encourage lawsuits because you're an attractive target. Assets, when they're held in LLCs, discourage lawsuits, and that's one of the things that why I have a skunk up there, is because people don't want to get around this because there's no benefit for them or their clients. So the limited liability company, it's a great tool. It's something that should be considered pre-RV to get your dinar into there. You ledger it in. You control it. You can gift it away. A lot of people are doing that. They gift it away to their kids. They control all the gifts. And then after it RVs, all your money will flow into the dinar, into the limited liability company, and then you'll be in control of it. So it works both sides of the equation. It protects it before RV, and then it protects your cash after the RV. One thing you want to make sure of, that when you set up a limited liability company, if you're using us or somebody else, make sure you've got a good operating agreement. Your dinar has been ledgered in. If you're going to gift, you have to make sure that you gift it the right way to your children. If they're minors, you have to gift it to the care of a guardian. That's really important as well, that you gift it to the care of a guardian, not to the kid directly. Won't work in that situation. And then you have a bank account set up. After the last call, I had a lot of people call me about the LLC and about how to get the bank account set up. I mean, that's something that we do when we set up LLCs. We have relationships with Bank of America, Wells Fargo, and Chase in Nevada, and so we can establish your account for you. So when this happens, you have the account set up, and you just roll the money right into it. Whenever you're considering an account, consider an account where you bank personally. Or use a bank, where you bank personally. For example, Wells Fargo is a bank I like. So all my business and personal accounts are with them, and I do that so that I can move my money back and forth just by getting on the internet. So that's something to keep in mind when determining which account or where to set up your account, which bank to use. But those are the three banks we work with. And really what we do is we get the whole thing set up, put a little bow on it, and it's ready to go for you. Then once this RV occurs, I mean, the money's there and you're in complete control. Now, that's one entity that I think is really important for a lot of people. But the most important entity I think everybody should focus on, which gets the least amount of attention. When I talk to people on a one-on-one consultations, we talk about the LLC, and I start to mention living trust. And at the end of the consultation, they say, hey, let's go with the LLC. I'll say, what about the living trust? Yeah, I don't know about that one yet. Well, I can tell you this, that I firmly believe that the living trust is the most important entity you will ever create, because this is an entity that you know you need. I mean, it's fact. We're all here for a limited amount of time. We try to make the best of it while we're on this planet. And so before that time occurs, we want to make sure that we've put things in place to ensure that our assets are going to go to our loved ones in a manner that we prescribe. And we haven't left it up to the courts, the legal systems, or an executor to run amok inside of our estate and just distribute assets as they see fit. This is what happens when you go through probate. If you do not have a document that keeps you out of probate, then your estate will be subject to an executor who will be controlling it and a judge who will be overseeing it. And I know just in my family alone, my grandmother, when she passed away, my uncle, he got hold of that estate as the executor, and he charged $75,000 to distribute an estate that consisted of 2 pieces of property and a couple bank accounts with cash in them. It was sick. It took him 4.5 years. Why 4.5 years? Because he was dragging it out intentionally in order to make money. And you take this small estate that my grandmother had, and you factor that exponentially to the estates that you're looking at having. And just think if somebody's in there, how long they could drag it out. Because I've seen this time and time again. The larger the estate, the more money, the fees that seem to get generated by the attorney, by the executor in the whole process. And I severely detest that from that standpoint because of the time, the emotional cost to your children, and unfortunately sometimes it's even the child himself does it to the siblings, as in the case of my uncle, to his brothers. But the other point about this, which a lot of people miss, is that you're looking for privacy. That's why you're setting up a Nevada LLC. That's why you're putting together trusts. That's why you're doing all these things, putting all these steps in place and these entities in place to have privacy during your life, and then you blow it when you pass away. Because probate is a public record. So everybody's going to know what you had, and they're going to know what your children have at that point in time because you've just laid it all out there. In many cases, it's going to be in the newspaper, and that's not what we want to do. What you want is a document that's going to bypass this probate process that is guaranteed to make a mess out of your estate and take forever to handle, and put it in the hands of a successor trustee through the use of this living trust that will pass it on free of probate. Literally, what is a living trust? Think of it as a large cardboard box that holds all your earthly possessions, and you put all your earthly possessions into this box and you lock it up, and now nobody knows what's inside of there besides you and your wife and your successor trustee when you pass away, because you can't see through the cardboard box. And so when you pass on, this cardboard box is handed off to the person you've elected to manage it after your death, to distribute the assets to the beneficiaries in the manner in which you prescribed. Now here's what most people miss out on when I'm talking about estate planning. They see themselves having a large estate, but right now they look at themselves as not having a multi-million-dollar estate, and they don't see the value in it. And I think that is the wrong way to approach this topic, because if you have dinar right now today, which you do, that's why you're on this call, and something were to happen to you and your spouse tomorrow, you're involved in a car accident, who gets it? Do they even know what it is? Most people will tell me they haven't divulged this information to anybody for the same reasons why I haven't, is because we want to keep it private. And so now you have this investment, you haven't told anybody about it, all of a sudden you've passed on, and they come into your house, they see this stuff, what are they going to do with it? Do they know what to do with it? I don't know, I doubt it. And so this needs to be specified in your estate plan so people know that you have this investment. If it has not RV'd prior to your passing, they know what to do with it. They know that it's not to be distributed right away to your children, because we don't want the 18-year-old son coming into $5 million. We know how destructive that can be. And so that's why that living trust will not only protect you after this RVs, might need to be tweaked a little bit, but before the RV, I think it is an extremely valuable tool to have, because it maintains your privacy. It gives a set of instructions to your trustee, your beneficiaries, about what's to be done with this investment that most likely they don't know what it is, and ensures that nobody's going to receive your assets until they demonstrate, maturity, or if you want to gift it away to a church, now you put instructions in there that you want a portion of your dinar, even though it has an RV, to go to your favorite charity. So somebody would go down to your church and describe to them what it is and give them this currency and tell them to hold on to it and wait for the RV to happen. This is extremely important. It's something everybody needs, but most people don't look at it from that standpoint because they walk around, they feel great today, and they don't think that, there's a chance that anything's going to happen to them in their lives. But, death is unpredictable. And I know this year alone, my wife's had 2 friends that passed away in their early 40s from aneurysm. So they're one day, gone the next. And what was extremely distressing about both situations that neither one had put together an estate plan. And there was chaos left in their wake. They weren't dinar holders, but they did have some assets, and they left behind some loved ones, and that's not what you want to do. You do not want to leave chaos in the wake of your estate plan. And so by putting together a living trust, you avoid probate, so you keep everything private. You expedite your estate distribution, or we hold it up. We don't give everybody assets right away. Kids, you say you can't get it until you're 35, possibly even 65 in some kids. You minimize estate taxes, and you minimize family disputes. Because that's what this trust, that's the essence of the trust, is to accomplish all of these facts. And so I would strongly consider that. So when I talk to people about these strategies, I often look at them and I say, we need to do a couple different things here. And one of the first things we're going to start with is we're going to create a limited liability company right here. And we're going to put your dinar into this LLC. You're going to be up here as the manager of your LLC, and if you're married, of course, then your wife's going to be up here with you. Both of you will be managers. You have this LLC, and then, of course, you're both going to be down here as members as well initially of your LLC. And so you're in both positions. You control it. This is control. And down here is ownership. So now, at this point in time, you've protected your assets. That's what we've given you, is asset protection with this limited liability company. We've given you privacy. We've given you a tool to gift but still control. Because now if you have children that you want to gift these assets to, say you have a daughter and you've got a son, this case, my case, and I want to give them each 10%, I'll gift them 10%, and then my wife and I are left with 40% apiece of this investment. But my wife and I are the ones who control it all. So after the RV, say we had $15 million inside of here. These kids may be jumping up and down thinking, oh, I get 1.5 of this. No, you don't. You only get what I tell you you're going to get. And that's going to come out to you when you demonstrate certain from a maturity level that I think you understand this and you can appreciate the value of the money. So that's the first tool that we talk to people about. And then we wrap that into this living trust right here, this big box. Let me see here. Let me go to a white screen so I can make it a little easier for you to see. So we create this big, huge box right here, and we call it a living trust. And in here, we place your limited liability company, again, with the dinar goes inside of there. We would tell you to put your house inside of there. Your vehicles go inside of this thing as well. And, if you have other assets, they would also go inside of this living trust. And so with this box that you've created, you're down here. You own it. You and your wife would own this box. And when anything happens, whatever's inside of this box, if you were to pass away unexpectedly, it would go down to your kids in the manner in which you prescribe inside of the box, because it has a set of instructions that we draft with it. And those are the two entities. When we talk about pre versus post RV, those are the two entities that I focus on now for people. And then I say, after RV, maybe we want to create a corporation. If you want to create a corporation, of course, that's going to go inside your living trust. We'll put a corp together if you want to get involved in some business ventures. If you want to buy real estate afterwards, maybe we'll create some LLCs for rental real estate. Possibly create that CRT. It sits outside of the trust later on. There's so many things we can do from here. This is our foundation. This is where you start. It creates a groundwork from where we can spring forwards. And so, a lot of people, when they go out to San Francisco, they're going to go out there, they're already structured, they're ready to go, and they can look at other options. Their eyes will be open. They can focus on other things and not on getting that first foundation set up. So for a lot of people, that's one of the reasons why they've been setting this up, is so they know after this occurs, they don't want to be worried, scrambling around trying to get their protection in place. They want to be scrambling around looking at how to invest their funds. So, everybody's different, though. It's not something that may fit in for you at this point in time, but it's something you should give serious consideration to, and that's why Dan asked me to come on the call and give you this information. So with that, I think, I went for about a little over an hour and 15 minutes. I've got my attorneys on the line here, and I want to open it up to them to see if there's any particular questions that were asked of any of you tonight that could be a benefit to the entire audience, and to answer those. Guys?
I think one of the important things is...
Go ahead, Michael.
Oh, I was just saying, in fact, how you brought it all together at the end, making sure that once the dinar does RV, that you've got the cash, that you protect it as well as be able to protect your heirs, get it on down through to the kids, but keep control over it through the living trust. So having all the pieces in place from an asset protection standpoint, and then also from maybe a probate perspective, is very important too.
Okay. I want to follow up on something here. I'm just looking at the questions that are being asked, and there's a lot of questions out here regarding how much does it cost for a living trust. A living trust is $1,500. That's what we charge to set it up. Of course, we draft everything for you based upon the questionnaire and consultations. The LLCs, an LLC for us to set up, everything we do is on a flat fee basis. It's $1,500. If you go to Nevada, it's an additional $695 for the nominee and the bank account and the other things that come with Nevada that you have to have there to really bring it all together. So those are the different fees that we have for those particular entities in setting it up. Somebody asked about taxation, on the LLC. Does it pay taxes? It doesn't pay taxes. It passes the tax liability down to you at your personal tax bracket. It's a flow-through entity. In many cases, we can set them up so they don't even have to file tax returns in the future. There's some tweaks that we put in our documents that make them a little different than a lot of people. And just, we've been doing this for 15 years, and this is all we do as a firm. So it's something we're really up on. Greg, did you have something?
Yeah, I had a couple of questions in regards to whether or not you should put the dinar in an existing LLC that's conducting business, or post-RV, if you should put your home or your vehicles in that same LLC. And we always want to remember that an LLC is a container for liability exposure. And so when we have an investment like dinar that's inherently safe, we would never want to put any other type of asset in there, like our home or our vehicle, that would potentially put the investment at risk if there was a slip and fall, or if we got involved in a car accident. We want to keep that dinar always independent from our other business or investment activity.
Okay, good. I'm looking through some of the questions that are coming up right now. Somebody asked, how do you protect a self-directed Roth IRA with dinar in it? James, I know a lot of people on here have invested through their IRAs in the dinar, and in that case, it really depends on your state. For most people, the IRA is protected already, so from an asset protection standpoint, you're fine. There's not much you have to concern yourself with, so you're good to go there. Let me see some other question here that I think is important. Can a single person be the only manager and member of an LLC? Absolutely. You only have to have one person. You don't have to have multiple people to create a limited liability company.
And there's been quite a few questions in regards to gift tax. Who pays the tax on a gift? It's not the recipient of the gift that pays the tax, the person that you give it to. If there's any type of tax liability on the amount that you gifted over, it's you as the donor of the gift that would pay the tax liability. But up until December 31st, 2012, we each can gift up to $5 million. That's our lifetime exemption. And so until we exceeded that $5 million amount, there wouldn't be any tax liability on the amount that we gifted away.
Tax for the, Michael asked, what's the low tax for a living trust? The living trust doesn't pay a tax. Everything, it's ignored for tax purposes. It's just you, so there's no tax there. Concerns with creating a living trust because it's disregarded. It's not like a irrevocable trust, how I started talking about those. This is completely different. It's set up strictly for estate planning. Consultations. Somebody said about consultations. Yeah, we offer consultations. If you're interested in our services, definitely just send us an email. Maybe some of the guys have already sent you their emails as well, where you can contact them and we can discuss your situation in more detail. That's also available. Let me see what else. Could Clint discuss some strategies? Gene wants to know for charitable giving, i.e. nonprofit foundations or 501c3, how do they fit in the overall plan? If you want to put together a 501c3, Gene, that's again something we would look at after the RV. I try to talk a lot of people out of 501c3s. I want them to set up private foundations, not the traditional, as many people see it, religious organizations. By going with a private foundation, it's much easier to operate and control, much less expensive for you to set up overall as well. But when you set up a foundation, I mean, the general rule is you have to give away 5% of your assets each year, and any money you put inside of them will continue to grow on a tax-deferred basis. But you cannot pull money out and pay yourself. When you set up the foundation, you're a disqualified party, therefore you cannot pull money out of it. Please speak about privacy. Is this mainly related to public records? What exactly does it mean? Who do we tell? How much information? Cindy asked this. Well, privacy is all about on a need-to-know basis, not on a need-to-show basis. When I discuss privacy, what I'm telling you is that you can decide who you want to let in on this information. I don't want it in my own name because that information is too readily available to anybody that has a computer. Anybody that hires a private investigator can find this information out. So when you create a Nevada LLC, the only people with whom you share the information, say your CPA, your attorney, of course, or people to whom you gift the interest, they're the only ones that are going to know about it. And, of course, the IRS and the bank. Everybody else could not discover this on their own because you're protected behind a nominee. Your name is not attached to the entity, and so that information is not made public to an individual. Got a question here. Can you bring together entities from different states into one living trust? Absolutely, Patrick. You can have all your entities from wherever they're held in the living trust. The living trust is not a Nevada trust. It's a state trust that's set up into your state. So, yeah, it's a big box. It holds everything wherever you own it. So that's fine. Kathleen asks, after RV, if an LLC is not set up as of yet, would it be to mess things up to cash in some dinar and then create an LLC, and would that be all right? Absolutely, Kathleen. The thing is that you're going to want to have this LLC. You either want it beforehand, for a lot of people are going that route, or you can do it after the RV. You want to get it set up for the asset protection that it provides. And so one way to do that, of course, is to cash in a small amount, pay for the cost of the LLC, get the dinar in there, and then cash in the rest so it doesn't run through your personal account. And so that's a good thing. Got another question from Don. My tax bracket for 2010 was at a certain rate. Will this be taxed? Will my taxes go up to 35% with the exchange? Depending on how many dinar you hold, Don, absolutely it'll most likely go up. If it comes out of what Dan's been talking about, what people have been speculating, yeah, you're going to be in the 35% rate. Jerry says, what happens if you don't have the money now to get started right now? Well, Jerry, if you don't have the money right now, that's fine. Don't try to scrounge it and try to scrape together to put these things in place. What you need to do is focus on what needs to take place immediately after the RV, and that would be to get some money and get the LLC, get the living trust done immediately, and then look at the post-RV strategies from that point on. So yeah, that works too. There's no problem with that. You know, I'm not telling you everybody needs to run out there and do this. I'm just telling you the benefits and why you should definitely consider it. But if it doesn't work for you at this point in time, I completely understand. And I'll tell you that, you know, I do tell people when I talk to them, hey, you know, wait, given your situation. What about a business trust? This is posted by somebody, Warren, wants to know about a business trust. A business trust, they used to be popular 20, 30 years ago, no longer so. Taxes is one big reason why we avoid business trusts. I'm not a big fan of them for that reason. And the asset protection may not be there. Typically it's not there that you're looking for. So I would just set up an LLC. I mean, it's simple, straightforward. I think it's one of the best strategies that you can look at. And then we're talking about strategies, pre-RV, if you're looking to gift away anything pre-RV and you're not setting up an LLC and you want to gift something away, then I think you should seriously consider gifting that now so you can minimize those gift taxes later. Somebody asked if we're in the Texas area. We're not. We do have Texas attorneys we associate with, but they're not there. They're in Nevada. So our offices are in Seattle, or actually Tacoma, and Las Vegas. Our firm, for those of you who are not familiar with us, we're comprised of attorneys and CPAs. So we do both the taxes and the asset protection with these entities. So here's another one. How are you taxed when you take money out of your LLC? John, this is a great question. I get this a lot. People want to know, if I have an LLC set up and I pull money out, is that taxable to me? And that's where a lot of confusion lies with these particular entities. The answer to that is no, it's not. The taxation occurs based upon what's generated inside of the LLC. That is, if your LLC makes money, then you pay tax on that money. If it doesn't make money, then you don't pay tax on the money. Distributions, the money you pull out, have no bearing on your tax liability. Think of it as a savings account. You only pay money on the interest that you earn inside of your savings account. You do not pay tax on the money you pull out of the savings account. So it's really straightforward and clean with a limited liability company. I'm going to answer a few more here, and then we'll sign off. If we have an existing LLC in Nevada, can we remove a partner? Annette, you can, but it's more difficult. So this call, that's a more advanced topic, but it can be done if you go about it the right way. Last thing you want to do is end up in a lawsuit, especially after the RV occurs, because there could be problems there. People say, hey, you pulled me out, you knew there was money inside of here, and you did it to hide money from me. For minor children, which is the best, setting up a trust for them or gifting pre-RV? I think the best strategy for kids is gifting it pre-RV and either setting up a trust or, again, the LLC and getting it into their name. I think that's the way to go, because we don't want our children to have control of the funds, and in this way, by setting it up in that manner, you're in control. They can do whatever they want. If something were to happen, they do not risk losing the funds that have been gifted to them. And sure, to maintain your maximum gift tax, definitely you want to set up a gift trust or a LLC for that. Can the assets of living trust be sued? Yes, the living trust does not provide any asset protection. That's a good question. People assume that it does. It does not. With the living trust, it's just there for estate planning, to keep it private. But when you for asset protection, you must have the LLC set up for that. So, hey guys, anything else? Greg, Michael, that
yeah, quite a few questions in regards to taxes. When you have an LLC, it doesn't generally have its own separate tax structure, and if you live in a state that has a personal income tax and you cash out your dinar, whether it's in an LLC in Nevada or Wyoming or any other Washington, a state that doesn't have an income tax, you still have to pay income tax in the state where you reside when you cash out that investment.
Okay. What do you physically do with the dinar after RV if it's put in to the LLC? Well, you have a bank account, Randy, set up with your LLC, so the dinar itself, the cash flows right into it. And, you're in control of this bank account. So the money's yours. After the RV, it's in your LLC, you're in complete control of the funds. I got a question here from Christine. Do you offer a mailing address for the Nevada for the LLC? Yes. When we set up a Nevada LLC, you have a mailing address, resident agent, nominee, everything. So your name, your personal information, nothing is disclosed to anybody. The only people that know about this LLC would be you, myself, your CPA, or if you use our CPAs, and the bank and the IRS. And in fact, the way it works, for example, my statements, I still, receive some physical statements from the bank on occasion. They're sent to Nevada, and then our office forwards them on. So I receive them. They come to me forwarded from that Las Vegas office. So that's the way it works. Here's a great one from people in California. If I move from California to Nevada before July 1st and cash out, can I avoid California taxes on my capital gains? Well, you know, Patricia, one of the things that California has stated in several opinions is that you would be responsible to pay California tax on that income that you generate after you move out of state. And this is pretty much uniform now by a lot of states who have a personal income tax. They're trying to capture as much money as they can because times are tough for the states. But, you know, it comes down to, do they know? Who's going to be tracking that? And so it's real difficult to track those types of transactions when you're out of state. But it does happen. I have a client right now that we fought in Montana, and he lost that one. I say he, you know, I've never lose a case. It's always my clients, right? In that particular case, they were very aggressive in their approach, and they did not look at the facts and circumstances of domicile, and they asserted a tax liability. Now, they made threats that they would come after them and do this and that to collect. It hasn't happened. It was mainly just posturing. But one of the things you need to be aware of is that they may make that claim. And so the further you are from when you exchange the currency to when you move out of the state, that time frame, the better off you probably are. But with that being said, it's not a bad idea. I mean, I would still do it and move out just to get out from underneath that extra 10% tax. So that's something you can do. How long does it take to set up an LLC? We can have an LLC set up for you in about 3 days. Bank account typically takes 8 to 10 days. That takes much longer. And that's just because it's the bank. I'm out of the process. Once we turn your information over to the bank, then they're going to be the one in contact with you. Here's a great one from Bradley. Do any of your fees go to taking Dan out for dinner? No, they do not, Bradley. We're a law firm. We don't split fees with anybody. We don't pay commissions, none of that stuff. But I thank you for putting that bug in his ear. I'm going to probably have to take him out to dinner now for this call. But no, when you work with us, there's no incentive there for Dan or for anybody on his website. One of the reasons why Dan recommends our firm and myself in particular, I mean, I know Dan. He's a client. We've done business together in the past, and what he's looking for, you know, certain quality in work and follow through, and that's what we provide our clients. I mean, we do it all for them, so they don't have to become attorneys on their own and figure out what wasn't done, which is something we find a lot when we go through people's paperwork. And I talk to them. I mean, just today I was on a call with somebody, and they said they had a couple LLCs, and yeah, they filed them, but they haven't drafted the operating agreements yet. So that's the reason why I think Dan chose to, you know, put these seminars on with us, and the fact that, you know, our knowledge, this is what we do when it comes to asset protection. And can I have an LLC, but my LLC bank in another state? This is asked by Troy. Yes, you can, but we prefer that if you have an LLC set up in Nevada, that you have a Nevada account opened up for it. Your state may require that you file, or the bank in your state want you to file your LLC in your state where you live. And in that case, you're going to lose the benefits of Nevada. So you may not like the 3 choices, but those are the only choices we have. And I think it's, you know, something you should consider, keeping that Nevada account open for that LLC. But your LLC can have multiple accounts. I mean, it can have as many different accounts as it wants. It doesn't need to have one. It could have 12. Because I know a lot of people are concerned about the $250,000 FDIC insurance, so you just open up multiple accounts. We do not use unincorporated business trusts, and so there was a question about that, and I've answered about, you know, how long it takes to set it up. We don't have any offices in California. Our offices, they stated, are just in Tacoma and Las Vegas, and yeah, pretty much a lot of these, I think we've answered a lot of them. If you have other questions, we do offer consultations. You can send us an email. You go to our site. There's on my website at alglaw.com. You can sign up for a consultation there, submit the consultation request, and we'll contact you to discuss setting up the entities. In general, talk about some strategies. That's available to everybody on the call, of course. We're happy to do that. That's one way to move forward, and we can discuss, you know, a lot of your questions off air. But I just want to thank everybody for taking the time tonight to be on this call. If you want more information on these topics, if you're interested, we're teaching another event. This one's in Las Vegas in another 2 weeks, and it's a more in-depth event. It's for a day and a half. It's a live presentation where you actually get to see me and the attorneys that are on this call will be presenting. We go into the stuff in detail and really get down to, talk more about post-RV strategies as well, but how the mechanics actually work and what you need to do from that standpoint. People often ask me, about a crummy letter, what are the elements, how do you put one together? We'll show you how to do that. And so not only can you participate via live, asking questions to the presenter while you're in the room, but you see us and you have a copy of the presentation. It's got the WebEx going at the same time. So it's a much more immersive type of event than just a standard webinar. But I got information on the site if you're interested. I think Dan's going to be on that one as well. I don't know why he didn't make it this evening. I know he jumped on for a little bit, but you guys got to give him some poke at him on the message board. He was supposed to be on here, and he didn't give me a heads up. But anyways, I want to thank you all for showing up tonight and taking the time. I mean, I enjoy doing this. I have a great time. This last hour and a half just whizzed by. And I want to wish you all the best with your investing, and I'm real excited about what's going to happen in the future. A lot of things are going on now, as are you, and I just want to, keep asking questions. It's a good way to build your knowledge, and I hope that, from this webinar tonight, you now have a good grasp of what the different options that are out there. And so if you hear some information, it just doesn't set right with you, take a pause. And if you want to, run a question by us, and we'll tell you whether or not we think that sounds about right. But also, always ask for authority. I mean, do not fall into this trap where you hear somebody, they said this is going to happen with the government. That's fine. People can say that all day long, but unless they actually have it in writing, they can point you to an actual site, a paper that's published by either the Inspector General or the Treasury Department, then keep that in mind, that a lot of times rumors are not necessarily based upon facts, and as a result, don't make decisions based upon rumors. Don't get really upset about it or concerned and then think things are going to change, because I've found many times that they're not based upon anything other than just pure conjecture. So with that, I'm going to end this tonight. I want to thank you all for taking time out of your evening to be on the call, the webinar, and I wish you the best with your investing. And again, if you have any questions, want to set up a consultation, contact us directly or go to our website and you can sign up there. With that, we're going to end it, and thank you very much. Take care, everyone.